Some analysis on the story. We're joined by Kristen Thomasen. She's an associate professor of law and senior chair of law, robotics, and society at the University of Windsor. All right, there's a lot here, and I can imagine people at home watching on TV, they're kind of thinking, okay, Indonesia, Malaysia banned it. UK brought in some kind of law. What's the situation in Canada?
As far as we've seen publicly, what has sort of been announced is that there are discussions taking place, but there's no expectation that Canada would ban the app. There has been some law attempted around making platforms more responsible for the things that happen. The Online Harms Act was under consideration, but it died on the order paper when the election was called, and we're waiting to see if that'll come back.
How concerned should we be about what Grok apparently can do?
It's concerning for a number of reasons. Of course, it's targeting people with just really, violent, sexually abusive conduct. So being able to sort of create non-consensual, intimate images of other people, and then especially with social media platforms, disseminate those at scale is very concerning. But it's also concerning just the extent to which there is this creation of these images in the sort of eye of the beholder or at the instruction of whoever is operating the generative AI tool, not just Grok. So it's other systems as well. And this is why we really need a structural approach in Canada and other countries, one that looks at the platforms, looks at the companies that make this so easy.
So one thing I'm always curious about, and I feel this comes right into your wheelhouse of expertise, is how much power does a country like Canada have when it's up against these tech giants, in this case, X and Grok, owned by the richest person in the world? Can Canada bring in a law that would protect people when it comes to Grok?
I think there is more normative power than maybe we give credit to smaller countries like Canada for holding. Demonstrating in law that this is not permissible and that there will be financial and other consequences as a result of creating these affordances or capabilities to produce this kind of abusive material, I think says a lot. We saw that with Clearview AI when the privacy commissioners in Canada found that it violated Canadian privacy law. The company's not operating here. Yes, it's still operating, but there is an important message that comes through when countries take these measures. And I think when we're talking about child sexual abuse material, when we're talking about non-consensual intimate images and the kind of threats that come from that, it's really important to, at the very least, send that message that the government is trying to do something.
So there's the state and its power to make laws, but then there are individuals who maybe collectively have a lot of influence as well. Any suggestions as to what we ought to do or what responsible users of these platforms should do?
Yeah, it is. It's an architectural or a structural problem. So it does need that kind of structural response, like a legal response. But at the same time, we as individuals do have a lot of influence and power, including through setting these social norms. If people left an application or a social media platform en masse because of this kind of abusive capacity, I think that sends a really important message, and it could have economic impacts as well. Resisting using different platforms that don't align with somebody's values, I think, is a really strategic approach. But in the end, I also think that putting pressure on governments or having expectations for governments and courts to take measures to allow for a more systemic response to this kind of problem is really going to be important as well.
Kristen Thomasen is an associate professor of law and senior chair of law, robotics, and society at the University of Windsor. I appreciate your analysis. Thank you.
Thanks for having me.